Hey guys, welcome to this video. My name is John Watts, and we're going to talk about a case from the Fifth Circuit Court of Appeals from a couple years ago. Very, very important case involving the Fair Debt Collection Practices Act, the FDCPA. And here's the basic gist, and then we'll get into the case. When a debt collector sends the initial communication, or at least within 5 days of the initial communication, they have to send you a letter under Section 1692G that gives you certain rights to dispute the debt, either verbally or in writing. And you can also ask for a debt verification or validation. But you have 30 days to do that. Well, let's say you do not do the dispute within the 30 days. But then after the 30 days, you notify the company, either in writing or verbally, that you dispute the debt. And then after that dispute, the debt collector updates your credit report and does not mark the account as being disputed. Can you sue under that, under the FDCPA? So the two competing arguments are, from the debt collector standpoint, they say, no, you can't do that because you missed your window to dispute the debt. That 30 days from that Section 1692G letter that we sent you. And by the way, we have videos on every section of the FDCPA where we go through the actual text, and you can look at those. And so they say, once you miss that, you can't come back later and dispute the debt and then require us to mark it as being disputed. And by the way, debt collectors hate marking stuff as disputed because generally it's not counted against you from a credit scoring standpoint if it's marked as disputed. Well, the other argument is from the consumer. Consumer says, who cares if I miss the 1692G 30-day window? I can dispute anytime. And under Section 1692E8, so it's E and then subsection 8, if the debt collector knows or should know the account is disputed, then they must mark it as being disputed on the credit reports. So that's the battle going on here. And this is the Advanced Recovery Systems case, or ARS, from 2017. So here's the basic gist. We've got in 2013, there's a couple of collection letters. These are hospital bills. The plaintiff says, I don't remember receiving those. Doesn't really matter, but it says, I don't remember receiving those. Point is, he didn't do anything with them. He says, I first found out about these debts when I ran my credit report. And so that was in February 2014. March 2014, he faxes a letter to ARS disputing the debt. He got no response. And so then about 45 days later, he runs his credit report again. And this is key because some courts say the debt collector, even after receipt of a dispute, has no obligation to update your credit report. But if they do update your credit report, they have to mark it as disputed. So here the company updated his information, but they did not mark it as disputed. So he sued them under Section 1692E8. And this is just a different way of describing that, but we'll use 1692E8. So they engage in discovery. That's where they ask each other questions. And then they both file motions for summary judgment. It's called cross motions because the plaintiff filed one. And then from the defendant's standpoint, they file one. It's like those motions cross in front of the judge. And so they're both saying there's no reason to have a trial. The facts are undisputed. The only question is legally, what does this mean? And so the parties told this to the judge. They said, look, there's no factual issues. Okay, in other words, it's clear that the consumer never disputed the debt within that 30-day time period. It's also clear he did dispute the debt after the 30-day time period of Section 1692G. And it's also undisputed the debt collector updated his report after receiving the dispute and did not mark it as disputed. So the court says, look, I'm going to throw out your summary judgments. And here's the question that I want you to answer. Whether a violation of 1692E8 is contingent upon compliance with the validation dispute requirements contained in Section 1692G. And the court enters judgment for the plaintiff and says, hey, you violated the 1692E8. Again, they're just using a different numbering system. and that 1692G does not incorporate, 1692E8 does not incorporate the validation dispute requirements found in 1692G. And so there's an appeal. And the court says basically about three arguments here. They said, look, the judge did not follow the procedures in Rule 56F, and then the judge made a mistake finding we violated that 1692E. And then they say, even if we did violate that, the plaintiff had no concrete injury, and thus he lacked Article 3 standing to bring this suit. And if you've watched our other videos, you know basically this comes up in every single case filed by a consumer in federal court. They say, you have no standing, no right to be in the federal court, and so your case should be thrown out. So the appellate court takes these arguments in consideration here in the same order. And they say, look, the judge didn't do anything wrong. And here the judge said, look, I'm telling you that I want you to brief this one legal issue, whether 1692E8 is contingent upon compliance with the validation dispute requirements in 1692G. That's what I want to know. And so everybody knew it. And even if there was some problem, it's harmless error. It doesn't matter. Okay. And the court says, look, just to sort of prove this, ARS, the debt collector, you agreed there were no factual disputes. It's really just a legal question. Just apply the law. So they get rid of that argument. Now here's the real meat of the case here, and then it'll end with that standing issue. So the court just very simply says that the trial judge did not make a mistake when he ruled that you violated 1692E8. Because here's what that law says. It says, you may not communicate or threaten to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. And importantly, the debt collector says, I admit, we did not put that it was disputed even though we were told that. However, they say, we don't have to because the consumer messed up. The consumer did not dispute within the time limit of 1692G. And so the court says, well, let's start with that. You're right. The consumer did not satisfy 1692G requirement that they must dispute their debt. It says in writing. It's not really in writing, but dispute their debt within 30 days after receiving notice from the debt collector. But they say, look, that is only in that section. It does not carry over to 1692E8. And they go back 20 years to Brady versus Credit Recovery. This is out of the First Circuit Court of Appeals. And let me just highlight this. Correctly stated that while the 1692G gives requirements for when a debt collector must verify and cease collecting on disputed debts, 1692E8 merely requires a debt collector who knows or should know that a given debt is disputed to disclose its disputed status to persons inquiring about a consumer's credit history. Now that would also mean when you report it to Equifax, Experian, TransUnion, Innovis, SageStream, whatever the credit reporting agency is, when you report this, you have to say it is disputed. And then the court says, well, let's look at what's called the plain language. So when we're interpreting statutes, this is always the beginning point. What's the plain language? What do the words say? What do they just mean in a natural context? And we look at that before we start saying, well, what do I think Congress meant when they wrote this law? Just look at the plain language. And they say, look, it contradicts the argument that 1692G carries over into 1692E8. And so then they quote pretty extensively from Brady here. And then they say, look, a consumer would be required to submit written notice within the initial 30-day time period. But the plain language of 1692E8 requires a debt collector to communicate dispute status if the debt collector knows or should know the debt is disputed. And they say this know or should know standard requires no notification by the consumer, written or oral, and instead depends solely on the debt collector's knowledge that a debt is disputed, regardless of how or when that knowledge is acquired. And then they said, applying the meaning of, quote, disputed debt, as you'll find in 1692G to 1692E8, would render that knows or should know language superfluous, like it's meaningless, okay? And so that's the end of the analysis. And so we have to be careful when we're looking at the FDCPA, because the sections don't always use the words in the exact same way. And so it might talk about who a consumer is. Well, a consumer is somebody who owes or is alleged to owe the debt. You find that in the definitions. But then when we're talking about has a improper disclosure been made, well, if we didn't have anything else, we'd say, well, the consumer's the consumer. If you told his wife, that's a violation of the law. If Susie owes the debt and you tell her husband, that's a violation of the law. But in the context of that, what's called third-party disclosure, it tells us a consumer is the consumer's attorney, or the consumer's spouse. So it defines it there. And so here we have to know, well, what is disputed debt? And that 1692E8 is just very clear, very simple. It says, hey, look, if you know, or you should know. So that doesn't necessarily mean it has to come from the consumer. Somebody could tell the debt collector, hey, that consumer disputes owing this debt. Well, that would qualify. And once that debt collector knows, regardless of who told the debt collector, regardless of when the debt collector found out, if they then update the credit report, they must mark it as being disputed. All right, so last thing, we won't look very long at this because we've talked about this in other cases, is the idea of standing. So we have these three elements that must be in place: injury in fact, and you can trace that to the challenge conduct of the defendant, and it can be redressed by a favorable decision. Basically, the second and third prongs in our types of cases are never in dispute. Okay? It's really the first one, suffered an injury in fact. And the debt collector said, as they do in every one of these federal cases, they say, the consumer did not suffer an injury in fact. And the court says, well, let's look at what the U.S. Supreme Court in the Spokio decision says. Concrete is not necessarily synonymous with tangible. Instead, the violation of a procedural right granted by statute can be sufficient in some circumstances, and that's where statutory violation creates a real risk of harm. And here they say, by failing to mark it as disputed when you knew it was disputed, that exposed the plaintiff to a real risk of financial harm caused by an inaccurate credit rating. And then they said, so the court properly determined that the consumer had standing. So they affirmed the judgment. Now, a couple footnotes. This is what the letter said, the dispute letter, is this is not a refusal to pay, but it's a notice sent under 1692G that your claim is disputed, validation is requested. So let me just sort of clarify this. So you get the validation notice from the debt collector, and it says, if you request in writing within 30 days, we'll send you verification of the debt, such as the name of the creditor or the judgment, or just verifying the debt in general. Now, technically, that only has to be sent one time. Some debt collectors send it every time. Well, if they send it, you've got the right to follow that. But if you are outside that 30 days, you can still send a dispute letter and say, I request validation. Now, they don't have to give it to you, and technically the word terminology would be verification, but courts use this interchangeably, validation, verification. Point is, you're saying to a debt collector, send me some proof that I really owe this debt. So you can request that at any time. Now, they don't have to do it if you're outside that 30-day window, but the key word here is disputed. And I don't care if that was sent 5 years after the 1692G notice was sent by the debt collector. Then the next time that debt collector updates credit report, it's got to show it as being disputed. And so, anyway, that's the case. The debt collection industry hates this decision. They say, "Oh, this is terrible," and the plaintiff got, I think, like a paralegal at a New Jersey law firm, copied something off the internet, some form dispute letter, sent it. It gave us no explanation for why it was disputed. We shouldn't have to acknowledge these sort of naked dispute letters. Well, that's what the law says. If you know the debt's disputed, you must mark it as disputed. It doesn't say unless you don't get a really good reason or unless you don't get any reason at all. It just says if you know it's disputed, mark it as disputed. It's a very powerful case, and I appreciate you watching this. If you have any questions, let me know. And if it's of kind of a private nature, if you go to either our main website, alabamaconsumer.com, or go to contactjohnwatts.com. That'll take you directly to our contact form. You can fill that out, and I'll get back with you. And hope you guys have a great day. Thanks for watching. Bye-bye.